Welcome back to the Financial Nexus. A jury verdict delivered this week in New Mexico has done more than award damages in a single case. It has fundamentally altered the legal landscape surrounding big tech accountability and established a precedent that could reshape how technology companies operate, disclose risks, and face financial consequences for platform design decisions. The $375 million judgment against Meta represents the first time a U.S. state has successfully held the social media giant liable for child safety violations, creating ripple effects that extend far beyond this individual case. The New Mexico verdict followed a 6-week trial where state authorities methodically demonstrated that Meta prioritized profit maximization over child protection across its family of platforms. Jurors sided with prosecutors who argued that the company violated multiple provisions of New Mexico's Unfair Practices Act through systematic failures to safeguard minors from exploitation and mental health harm. The case established that platform design decisions, which knowingly increase engagement through psychological manipulation, can constitute legally actionable harm when those decisions target vulnerable populations. What makes this verdict particularly significant is its timing within a broader legal offensive against Meta's business practices. Within 24 hours of the New Mexico judgment, a separate Los Angeles jury reached a similar conclusion in an individual case involving a 20-year-old plaintiff known as KGM. That jury found Meta knowingly designed its applications to be addictive to children and teenagers, thereby endangering the mental health of users during critical developmental periods. The convergence of these verdicts within a single day signals a fundamental shift in how courts evaluate the relationship between platform design and user harm. The financial implications of these precedents become staggering when viewed against the scale of pending litigation. Legal experts estimate that thousands of cases similar to the Los Angeles matter are currently working their way through the court system, each representing potential damage awards that could range from hundreds of thousands to millions of dollars per plaintiff. Simultaneously, 40 state attorneys general have filed lawsuits against Meta that mirror the approach taken by New Mexico, creating exposure to additional multi-hundred-million-dollar judgments across multiple jurisdictions. The legal theory that emerged victorious in these cases represents a significant evolution in how courts understand technology company liability. Rather than treating social media platforms as neutral conduits for user-generated content, these verdicts establish that companies can be held responsible for the psychological effects of algorithmic design choices. The courts found that Meta's internal research demonstrated clear knowledge that certain features increased addictive behavior and mental health risks among teenage users, yet the company continued to optimize for engagement metrics that amplified these harmful effects. The evidentiary record that supported these verdicts provides unprecedented insight into Meta's internal decision-making processes regarding child safety. Depositions from Meta executives, including CEO Mark Zuckerberg, revealed company communications acknowledging the mental health risks associated with platform usage among teenagers. Internal studies showed that Instagram usage correlated with increased rates of depression, anxiety, and body image issues among teenage girls. Yet these findings were not reflected in public safety measures or algorithm modifications that might have reduced engagement-driven revenue. The business model implications of these verdicts extend beyond immediate financial penalties into fundamental questions about the sustainability of attention-based revenue models when applied to vulnerable populations. Meta's advertising revenue depends on maximizing user engagement time and emotional intensity, creating algorithmic incentives that directly conflict with child safety objectives. The legal precedents established this week suggest that courts may no longer accept this conflict as an inevitable aspect of digital platform operations. The regulatory landscape surrounding child online safety is evolving rapidly in response to these legal developments. Multiple states are considering legislation that would require social media platforms to implement specific design safeguards for minor users, including restrictions on algorithmic recommendation systems and mandatory parental controls. The European Union has already implemented similar requirements under its Digital Services Act, creating international pressure for American companies to modify their global platform architectures to comply with child safety standards. The investment implications for Meta and other major technology platforms are becoming increasingly severe as this legal trend accelerates. Investors are now pricing in potential liability exposures that could reach into the tens of billions of dollars when multiplied across thousands of individual cases and dozens of state enforcement actions. The company's market valuation has already reflected concerns about regulatory compliance costs, but these verdict precedents suggest that the actual financial impact may exceed current market expectations. The precedential value of these cases extends beyond Meta to impact the entire social media industry. Platforms including TikTok, YouTube, Snapchat, and Twitter face similar algorithmic engagement strategies that prioritize user attention capture over safety considerations. Legal experts anticipate that successful plaintiff attorneys will adapt the evidentiary approaches used against Meta to target these other platforms, creating industry-wide exposure to child safety litigation that could fundamentally alter how social media companies operate. The international dimension of this legal development adds additional complexity to the financial and operational implications. Meta operates globally, but faces different regulatory frameworks regarding child protection and platform design requirements across various jurisdictions. The American legal precedents may influence how European, Australian, and Canadian regulators approach platform accountability, potentially creating a cascade of compliance requirements that force fundamental changes to algorithmic operations worldwide. The technological response required to address these legal risks involves more than superficial policy changes or enhanced parental controls. Courts are increasingly sophisticated in evaluating whether safety measures actually modify the underlying algorithmic incentives that drive harmful engagement patterns. Cosmetic adjustments that preserve revenue-generating features while claiming to address safety concerns are unlikely to provide meaningful legal protection against future litigation based on these precedents. The timing of these verdicts coincides with broader societal concerns about technology's impact on mental health and democratic institutions, creating additional momentum for regulatory and legal action against major platforms. Public opinion polling consistently shows declining trust in technology companies and increased support for government intervention in platform design decisions. This political environment makes additional legislative and regulatory action increasingly likely, compounding the legal risks established through these court decisions. The financial services implications of this trend extend beyond direct investment in technology stocks into broader questions about platform-dependent business models across multiple industries. Companies that rely on social media platforms for customer acquisition, brand building, or direct commerce face potential disruption if platform design requirements fundamentally alter user engagement patterns or advertising effectiveness. The ripple effects of child safety compliance could reshape digital marketing strategies across the entire economy. The insurance and risk management implications for technology companies are also evolving rapidly in response to these legal developments. Traditional technology liability insurance policies were not designed to cover the scale of damages now possible under child safety litigation theories. Insurance companies are reassessing coverage terms and pricing structures to reflect the new legal reality, potentially making comprehensive liability coverage prohibitively expensive for platforms that continue operating under current engagement-maximizing algorithms. The competitive dynamics within the technology industry may shift significantly as companies respond differently to these legal pressures. Platforms that proactively implement child safety measures may gain competitive advantages through reduced legal exposure and enhanced regulatory relationships, while companies that resist changes to revenue-maximizing algorithms may face escalating legal costs and market share losses. The differential impact of compliance costs could accelerate consolidation within the industry or create opportunities for new entrants with safety-first design philosophies. The international trade implications of divergent child safety regulations could also reshape how technology platforms operate globally. If American legal requirements become significantly more stringent than other jurisdictions, platforms might consider geographic segmentation of their services or selective market exits to avoid legal exposure. Such decisions would have profound implications for global information flow and digital economic integration. The enforcement mechanisms for these new legal precedents are still evolving, but early indications suggest that state attorneys general are prepared to pursue aggressive litigation strategies that could result in additional multi-hundred-million-dollar settlements or judgments. The success of the New Mexico case provides a roadmap for other state enforcement actions, while the individual plaintiff verdicts demonstrate that private litigation can also generate substantial damage awards that create meaningful financial deterrence. The long-term implications of this legal shift may extend beyond technology platforms into broader questions about corporate accountability for psychological and social harms caused by product design decisions. If courts continue to hold companies responsible for the mental health effects of engagement, optimizing algorithms, similar legal theories might be applied to other industries that use behavioral psychology to influence consumer decision-making, including gaming, retail, and financial services. Understanding these developments becomes crucial for investors, technology companies, and policymakers as the legal framework governing digital platform operations undergoes fundamental transformation. The intersection of child psychology, algorithmic design, and corporate liability has created new categories of business risk that traditional financial analysis may not adequately capture. Thanks for joining us for this analysis of the Meta child safety verdict and its implications for technology industry accountability. The legal precedents established this week represent more than isolated judgments against a single company. They signal a fundamental shift in how courts and regulators will evaluate the relationship between platform design, user harm, and corporate responsibility. We'll continue monitoring these developments as they reshape the technology sector and examining their implications for investors and institutions navigating this evolving regulatory landscape. Make sure to subscribe for continued coverage of the legal and financial forces transforming the digital economy.